So we're now going to have a panel where you get to ask questions of the speakers you've just heard. I was originally supposed to ask them all a question first, but we're short of time, so I think we'll go straight to audience questions. So could I ask Fiona, who's already getting up, and Michael and David to take their seats in the comfy chairs. And as I'm not going to ask specifically any questions, I might stay standing up here so I can better see all of you. There will be roving mics. I'm not sure who's Deb and someone else is delivering, and Jack are going to run around and do the roving mics. Just a reminder, we want a question. So who would like to ask the first question? There's a gentleman down the front, and then after him, the lady over there.
Thank you. I'm not a lawyer and utterly naive. I can't understand how chaplains in the army or in schools can be legal, constitutional. Is there any chance that this issue can be revisited and let's have them abolished?
Well, yeah. So there's two species of law. There's the law in the books, which is the law that Michael enforced when he was a judge. It's the law that David would argue about when he was a barrister. It's the law that I teach to my students. But then there's also the law in the streets, how the law actually plays out in practice. So in terms of military chaplains, when I showed you the section 116 of the Constitution, that last bit, no religious test shall be required as a qualification for any office under the Commonwealth. Chaplains are military officers, just like artillery officers or any other kind of military officer. And it's a selection criteria for those jobs that you be of X, Y, or Z religion. So it's kind of an anti-discrimination, a religious discrimination provision in the Constitution. And plainly, the hiring of chaplains is in breach of that. Quite plainly. The problem is, nobody has ever gone to court to challenge it. And so politicians and governments have this concept of legal risk. We saw this in robo-debt in its most sort of foul form. We reckon we'll get away with it, so we're going to do it anyway. And so this is what the government lawyers call legal risk. It's probably illegal for whatever reason, but we're probably not going to be called out on it, so we'll keep doing it. So Commonwealth spends billions of dollars on all sorts of things they don't have power to spend money on, and they do things like military chaplains, which is in breach of that anti-discrimination rule in the Constitution. School chaplains is a similar thing. It's not a constitutional issue, but there are religious discrimination laws in every state and territory except here in New South Wales and South Australia, where it's illegal to hire or fire people on the basis of religion. So in Victoria, if you put out a job ad for a barista at a cafe and say must not be Catholic, that's a breach of the law. If you put out a job ad that says social worker in school must be Christian, that's in breach of the law. But again, no one's yet gone to court to challenge that. And that's the issue. Someone with standing, so someone personally affected by it, the issue, would have to go to court to challenge it. And going to court is really risky because if you lose, even on a technicality, not only do you have to pay your own lawyers, you've got to pay the other lawyers for the other side. And so you might risk your house, you might risk bankruptcy. State anti-discrimination commissioners have said that school chaplains are in breach of state anti-discrimination laws, but they decline to take any action about that. So they're on the public record saying that.
Well, that's what Ron Williams had done, had challenged it.
Yeah, so Ron Williams' case was a challenge to the funding arrangements of school chaplains rather than the discrimination aspect of school chaplains. And so they've worked, so the Commonwealth can't fund school chaplains directly, so what they do now is they give the money to the states and then the states do it, and so that gets around the funding issue.
There was a famous case in the High Court, the Dogs case, Defence of Government Schools. And in the High Court, Lionel Murphy, one of the justices of the court, was the only justice who upheld the challenge that you could not provide money to religious schools. Essentially the reasoning was very, very narrow and very particular, which, as Luke has pointed out, wasn't required if you had regard to the history of the clause that it came from the United States. In the United States, they've got really rather strict constitutional holdings that prevent a whole range of political action in the public space. But the High Court said, well, its focus is on not establishing any religion. That means not creating a Church of England, which has a state function, and that there was no other foundation to raise the issue of the funding of church schools. In my time on the High Court, just towards the end, when the power was about to slip from my hands, we had a case brought to us seeking to challenge the funding which Mr. Rudd had made available to the Roman Catholic Church for World Youth Day. Does anybody remember World Youth Day? It was the celebration of a particular religious denomination, and it was a huge amount of money. I think it was $50 million, $100 million. It was a lot of money. So they came up before Justice Crennan, and she had been raised in a Catholic faith, and she struck out the procedure, saying it was not arguable. That was then challenged, and it went to the Chief Justice to assign the bench. But he was challenged then because he was himself a Roman Catholic. So it ultimately led to a bench comprising of myself, Justice Gummow presiding, and Justice Hayden. Justice Hayden went to Shaw and was an Anglican. I went to public schools. Justice Gummow went to Sydney Grammar School, which is non-denominational, but they interpret that to mean secular. So it came up, and two of the justices, Justice Gummow and Justice Hayden, said that this is not arguable. And I never quite understood why it wasn't arguable, but I understood that it was suggested that the dog's decision stood in the path, and therefore that the court, unless it reopened that, would not go further. I then went away at lunchtime, and I prepared short reasons, but not so short. They were about 5 pages, why I would allow it, and if it required leave to challenge the dog's case, we should give it, that was an arguable case to reconsider because it was a very narrow interpretation led by Barwick against Murphy. And that was, I pronounced those reasons, but for some reason the law reporters have never published that. I said it was timely to reconsider the dog's holding, and it's never been published. I'm thinking that the time has come for me to write a very erudite legal article and to publish it and to annex the very short statement by the majority that this is not covered. This is covered by dogs, and no, we're not going to go back there. And mine, which was saying, well, we ought to reconsider it, and that is of itself a serious question that ought to be ruled on by the court. But it ought to be in the public space. It's, I thought, one of my more brilliant and certainly one of my briefest opinions.
But it does go to show when you have a majority in an institution, whether it's Parliament or the High Court, that refuses to look at it, even if there is a glaring constitutional problem, if the majority just will not look at it, the institutions fail. And I think we see that in a number of occasions in this space. I've definitely felt it.
Can I just add that during the whole of my service on the High Court, virtually the whole, I was the only Justice of the High Court whose entire school education had been in public schools. The coalition tended to appoint people who had gone to private and religious schools. The Labor Party tended to appoint Roman Catholics who'd gone to Catholic schools. And I think that may have influenced the subconscious opinions. To the credit of the Albanese government, the three justices that they have appointed are Justice Gaigler to the Chief Justice role, and he went to Muswellbrook High School.
Excellent. Now,
They also appointed Justice Jago, who attended Normanhurst Girls' High School. Normanhurst is a very great school. I've been there. I'm surprised that you don't claim it. I know you're.
I went to Normanhurst Public, the primary school.
can I
and
just
my brothers went to
interrupt you
Normanhurst
there
High.
with these reminiscences of where you went to school, which is wonderful, and we may well get to it again later. But we are running out of time, and there's a lady over here with a mic who wants to ask another question. I'm sorry, everyone, we might make that the last question and then go to morning tea. Hold your horses. I'm sure you'll get chances to ask again.
Yeah, hi. I had a burning question for Fiona. You talked about, it was just something you'd mentioned that the sex workers it was illegal in Victoria, for them to work outside of school, naturally, and outside churches. Did they also apply that rule to other religious institutions such as temples or mosques?
Yes, it was all. It wasn't mentioned in any of the second reading speeches, but the legislation did say, religious institutions. I have to say, they never had solicited outside churches or any form of religious place. So it was always a little bit curious as to why they wanted to submit this ban. And when we were looking at, when you look at street sex workers being probably some of the most marginalised people, many experiencing homelessness, many experiencing issues with drug use, the last thing you want to do is criminalise those people. You really want to help them. And any form of criminalisation just seemed stupid.
But soliciting inside is okay?
Thank you.
Oh, yes.
Yeah.
Yes. Without doubt. Without doubt. Although they seem to always insist on getting it for free, don't they?
Yeah. Indeed. I'll never forget the fear on some very respectable, conservative-looking men who got a Qantas flight with me when we got into the Los Angeles airport, and we heard this thing come over the tannoy saying, "No solicitors in the airport. No solicitors in the airport." And the panic on their faces was a joy to see. But I digress. Can we please thank our wonderful panellists? I'm sorry it's been so brief, but we were so fortunate to hear their wonderful presentations, which covered so much ground and basically set, I think, the agenda for the rest of the day.